Corporations number 7 committee. Welcome to the 200th day of legislature. Today we'll have Senate File 28 and Senate File 82, starting with Senate File 28 engrossed. Could you please take the roll?
Representative Brown,
Present.
Representative Heft,
Here.
Representative Johnson,
Here.
Representative Locke,
Present.
Representative Lucas, Representative Webb, Representative Weber, here, Representative Yin,
Here.
Chairman Knapp.
Here.
Mr.
Thank you.
Chairman, you have a quorum.
All right. So first up, we have Senate File 28 engrossed. This is elections, voting machine, and voting system tests. And let's see who we have presenting here. This was a joint corporations. So normally we would have somebody present this. I'm going to ask the Secretary of State's office to present the bill. And then we'll follow up with questions. No.
Well, what a pleasure it is to be here. Thank you, Mr. Chairman, members of the committee. I'm Chuck Gray, the Wyoming Secretary of State. I'm joined by Joe Rubino, our Policy Director and Counsel. And I'm here to testify in full support of Senate File 28, which again pertains to voting machine and voting system tests in Wyoming. This was one of our key interim requests. As I'm sure you remember, we had a great bill in the 25 session that was sponsored by Representative Tony Locke that unfortunately was not heard over in the Senate. It was not heard over in the House on general file. That actually happened, I believe. They ran out of time on the House on general file, passed out of committee. And this is a very well vetted bill. And let's start with the 30,000 feet up before I walk through also what it does more from 10,000 feet up, and then I'll go through the text itself. And from 30,000 feet up, what we're trying to do is fix some of the issues that were identified in the 2024 election with respect to testing. The impetus for this bill is really about ensuring clarity and rigor in the public testing of our voting equipment prior to elections. Wyoming law currently requires the testing of voting machines prior to an election to run a predetermined number of ballots through our voting equipment to make sure the equipment is tabulating our votes accurately. And one of the key requirements in this process, as outlined in 22-11-104B, Romanet 3, is the requirement that during the test, quote, a different number of valid votes shall be assigned to each candidate for an office and for and against each measure. And this requirement isn't just a formality. It is crucial to ensuring that the electronic voting machines are accurately counting and tabulating the votes for each candidate when the actual ballots are tabulated on election night. However, during the 2024 election cycle, specifically prior to the 24 primary election, there were issues that were brought to our office's attention that some tests did not assign a different number of votes to each candidate as required by 22-11-104. In response to these concerns, I sent a letter asking the counties to retest their voting equipment to comply with 22-11-104. The vast majority did. There were 2 originally that had done it correctly. Of the 20 that we sent to, I believe 18 retested, but some did not, citing their belief that the statute did not allow them to retest and open up the seals once the test was completed. We're glad that 18 counties agreed with our interpretation that, of course, if a test has not been done accurately, a retest is allowed, and the seals, if they need to be broken in order for a retest allowed, could be conducted. But one of the things this bill does from 30,000 feet up is it clarifies that question. And of course, we consulted with the Wyoming Attorney General on that question as well in terms of existing statute. Through the numerous discussions that we had with both the clerks as well as members of the public, there were a number of questions raised concerning the testing of voting machines, specifically with respect to the following issues. 1, the timing of the logic and accuracy test, the notice provided, and the ability to retest. Number 2, the ability of the public to attend the testing, which of course from common sense is very important, and the posting of notice to the public for testing. 3, what it exactly means to assign a different number of votes to candidates under both the title and the spirit of the law to ensure the equipment is counting votes accurately. These were all questions that, one, we wanted to ramp up rigor in the statute on, and then also ramp up on clarity, because every time it happens, the state, being represented by myself at this time, the Secretary of State, and the 23 county clerks, oftentimes have widely variant views of what the statute says. So we want to ramp up clarity, and then we also want to ramp up rigor, specifically with these 3 questions. I really appreciate the work that the Joint Corporations Committee put into taking on this issue on and listening to our concerns and trying to achieve clarity in our statutes governing the testing of voting equipment prior to elections and rigor. Want to reiterate what this bill does a little more fine-tuned, kind of now we're getting down to 10,000 feet. It was more of a 30,000 feet up, the questions that we were trying to address. But now, as we go more at 10,000 feet up, what this bill does. First, I think it clears up any questions concerning public notice and the ability of the public to observe this process. 2, it addresses the direct issue and questions we received in the 24 primary. It provides that write-in candidates are treated like other candidates for purposes of assigning a different number of votes to test the machine's ability to accurately count votes. And that was one of the big questions on how write-ins are handled with this existing statute on different number of votes for each candidate. 3, it provides that every machine should be tested that is to be used in an election. That is very important. One of the things that specifically one county clerk in the county, Laramie County, asserted was something that I was very troubled by, which is that the current statute does not address express votes, meaning ballot tabulators, electronic tabulators. And of course, Laramie County, that is the default method of voting, where you have an electronic tabulator that is spitting out a ballot that you then put in to the official tabulator that is tabulating the vote off of a barcode. So you have 2 parts of the process on when you have there's 2 parts of the process in that situation. You have, which is different from the other counties, you have the touchscreen where you're marking. That's called the ballot marking device that spits out the ballot that then you're inserting into the tabulator. So as opposed to the 22 other counties where the default method of voting is pen to paper ballots, where you're filling out a ballot and then you're inserting it into a tabulator, in an express vote situation, you have 2 steps of the process. And many clerks, including in Laramie County, where the default method of voting was interpreting that express votes weren't covered in certain situations. So express votes need to be tested, and every machine needs to be tested. And this bill clarifies that. Clearing up inconsistencies concerning timing, number 4. Clearing up inconsistencies concerning timing of tests and the ability to retest, not just because of an error, but because of any non-compliance with law. And then 5, providing that a list of the equipment tested is available to the public. So that's sort of at 10,000 feet. So now let's land this plane and go line by line. Page 1, of course, we got the bill title pursuant to the Wyoming Constitution, the enacting clause pursuant to the Wyoming Constitution. Then in page 2, you start to get amendments to existing statute and a little bit of windup. And this is on the notice requirement, what you see on page 2. In the engrossed version, it says not later than 2 days before a test of a voting machine or not later than 24 hours before any retest of a voting machine. Post a public notice in the office of the county clerk and on the website of the county clerk. And then further down, some of the parameters around that. At the county clerk's discretion, not less than 3 members of the public, but not more than a number that will ensure the orderly testing of machines and members of the public. That was a Senate amendment, which I'm not sure totally makes sense. We have an amendment to a few of these provisions because they did, in my opinion, weaken the original committee bill. We'll get to that in a moment. Then at the bottom of the page, representatives is clarified to attendees. Moving to page 3, in subsection B, inspection shall begin not less than 2 weeks before an election and continue until all machines to be used are publicly tested and sealed. That actually clarifies an area that there was some disagreement with the clerks on whether the previous statute had been interpreted to require it on one specific day rather than across a range of days. This kind of clarifies that issue, that it is across a range of days. Bottom of page 3 and onto page 4, a copy of this certificate shall be filed with the Secretary of State, and the certificate shall be kept on file in the office of the county clerk. That's the certificate that states that they conducted the test. Subsection C, no voting machine shall be used in any election unless the individual machine is tested and prepared in accordance with this section. Every voting machine used in an election, including but not limited to all electronic ballot marking devices, shall be individually tested. That's a very important subsection. And then in objections, the Senate amendment, you can see that they made it that it has to be challenged within 5 days after the machine is sealed. The current requirement in statute is 2 days. The committee tried to make it any time before the election. So it will be any period between the test and the election. And we believe it should revert to the committee language, and we'll hand that out in a moment. But I'm working off the engrossed copy. Page 5, it just inserts that the rules that governing this could include testing rules and on the systems. Page 6, again, you have this sort of repetition in the statute on the systems versus the equipment. So this is the repetition on the notice, who can attend. And then on the bottom of the page, you see this new language that it has to be on all ballot styles that may be used in the election. So that is language that didn't occur earlier in the bill, whereas the first 2 clauses did and are repeated for this other situation in the statute. Again, it's equipment versus systems. Page 7 is where we really try to drill down into the electronic ballot marking device situation. And this is beautiful language. If the county uses an electronic ballot marking device in any way, the test shall also be conducted using ballots or ballot cards on each machine that are marked by an electronic ballot marking device. And then in the middle of the page, you have this clarification on what it means to be a different number of votes for each candidate and how to handle undervotes and overvotes. Then as you work your way down the page, you can see these sections on being able to retest. If any error is detected, then you get the new language, or if the test is not completed in compliance with law, ... Then you go back to new language. The results reported in the same manner official election results are reported shall be retained by the county clerk, posted to the county clerk's website, and a copy of the results reported in the same manner official election results are reported shall be provided to any person upon request. So that nips in the bud some of the problems we had in 24 on providing the results of the test. There was a few clerks that said that they could not be provided to the public. We had them, we asked for them, and we provided them to the public pursuant to our interpretation of law. And then page 8, you get a little nip in the bud here on provided that if a retest is required, the seals may be broken so that an errorless count can be secured and certified as provided in this paragraph. So that's where you really nip in the bud the retest issue, which came up in the 2 counties that refused to retest. This is a very important bill. It's a very technical bill, but it's very important in providing rigor and clarity in terms of machine testing in Title 22, the election code. So I stand in full support of this bill. We've been working on this one for a year and a half, and let's get it done.
Thank you, Mr. Secretary.
Excuse me. Okay, thank you. Can I have a copy, please?
Before we go to the amendments, I
Yeah.
just had one question. So if a seal is broken because you had to retest, and then once that's done, is there a new seal applied after that?
Mr. Chairman, I certainly would interpret the code as requiring that, but if you think we need to provide a bow on that, certainly let's do that. And I'm all for clarity in this code. If I've learned one thing in three years in this job, there's not there. You can always go for more clarity on these because there's wide disagreements on what many of these statutes mean.
All right, thank you. Go forward with your amendments.
Thank you, Mr. Chairman. Now, I want to be clear, all of these amendments, and Mr. Rubino, correct me if I'm wrong, we were working this in today, they all move the bill back to its original committee version from Senate amendments that were made. So this takes the bill closer. It doesn't reverse all the Senate amendments. There were a few that I felt were fine, but there are a few that I think go against rigor, clarity, and I think we need to get closer to where we originally were. So it basically moves this notice from 2 days to 4 days. The engrossed version was 5 days. Obviously, if committee wants to do 5, I think I'm open to that. It also deletes this section on page 2, lines 12 through 14. At the county clerk's discretion, not less than 3 members of the public, but not more than a number that will ensure the orderly testing of machines. I really think we should just say the public is allowed in and let the clerk sort of have the obvious discretion. I mean, obviously, if it's unworkable, at some point you've got to say it's unworkable. But I think putting a number on how many people you're going to have there, a maximum, or, it just doesn't. And then also, in my opinion, and Mr. Rubino was, I think, in large alignment, not sure the engrossed copy in that area really makes sense. It says, at the county clerk's discretion, not less than 3 members of the public, but not more than a number that will ensure the orderly testing of machines and members of the public. So there's multiple ways, I think, to interpret that. And I certainly don't think it's clear. And then page 4, line 16, it deletes this 5-day requirement for challenge and takes it back to the engrossed version where you can challenge the test in district court with a petition up to the day of the election. Now, hiring an attorney, having the attorney prepare a brief, I mean, only providing 5 days for that rather than, what would it be, 2 weeks under the engrossed version, closer to 2 weeks. I just think, there was a lawsuit filed, and providing that time for an advocate to put together their argument in a coherent way, I think we should provide a few more days for that rather than saying that you have a 5-day requirement. So I think we should go back to the committee passed version. Page 6, line 2 is again moving the 2-day notice to 4 days because that section is repeated. So it doesn't take it all the way back to 5, but I think at 4, maybe we end up at a happy medium. But I think the Senate position is way too the other way. And then page 6, line 11 through 13 just provides the conforming amendment for page 2, lines 12 through 14.
Okay, thank you. Are there any questions from the committee on the bill itself or on the amendments? The Secretary of State? No questions? All right. Thank you very much. We'll hear from any agencies, any other agencies, and then the Clerks Association. Hello, Ms. Langford. Please identify yourself and.
Mr. Chairman, I'm Mary Langford and I have the honor of representing the county clerks of the state of Wyoming. And good afternoon to you as well as to the members of the committee. We've been involved in this bill and I have a couple things to focus on here. Our purpose here to focus is on administration of Wyoming elections and the testing of machines and systems. This bill provides for posting and clarity that testing is done before the public. The county clerks on the Senate side had proposed several amendments. And we agree with the bill, except for I'm going to push back on the Secretary of State's amendments that he just presented. The amendment for the 5 days to the 2 days to the 5 to 4 days, those were county clerk amendments that were proposed. And the purpose of that being was that To ensure that the county clerks have sufficient time to provide notice, although each county clerk may strive to provide for 4 days' notice or 5 days' notice, ballot printing errors, delays in obtaining ballots, or other unseen circumstances may impact when a county clerk is able to test equipment. As such, we request the following amendments to stay at 2 as opposed to 4. And that would be on line 2 or page 2, line 2. And it's also on page 6, line 2.
Okay.
The 2 Senate amendments, those were added after discussion before the Senate House Committee. There was some concern about, we discussed the size of the room and how many people would be allowed to be there and to be able to have secure testing and those types of things. And that was their concern for providing those amendments that they did on the floor to make sure that we would have enough room. Because we'll test this equipment, then we'll seal it, and it's all part of your chain of custody. It isn't like you're gonna roll it out and move it someplace else. You're testing it and securing it to have it ready to go to the polls on election day. And then on page 4, I have a question, and I don't, probably not, I guess just a concern and a question. Where it talks about under the objections and to remove the challenge for 5 days. So is there a hard stop then when you can't challenge? It's up to election day. But how does that affect the election if you're that close to the election day? So if your challenge came the day before the election, does that stop the election or what happens with that? So. And to follow up on one question that was posed, Mr. Chairman, from you concerning resealing machines. So once they do retest, yes, they will reseal those. They keep track, the seals are numbered. They keep track of those seals. They're checked, they're recorded at the clerk's office, but then they're also checked when they go to the polling place. And they note that that same seal is still on the machine that went from the clerk's office to the polling place. Then they're sealed again to come back. So, yeah, they would be sealed twice.
And, and I know that's implied, but do you think that should be clarification within the statute itself?
You know, really, that's standard procedure. So I don't see a need for it to be statutory. I think it's standard procedure with how you, go through your testing and your sealing. And there's procedures that they have to do that. So I think it's fine. So, Mr. Chairman, otherwise, excuse me, I've got a frog in my throat. Otherwise, we're fine, except for that we would push back on those days. We'd still like to have 2 days. So.
All right, questions? No questions from the committee? All right, thank you very much.
And then one other thing, I believe we might have somebody online.
Oh, okay. For the association?
Yeah.
Or for just a clerk?
I think Julie Freeze was planning on, the Fremont County Clerk was planning on signing.
Okay,
but
we'll
I'm
keep
not
her in
sure.
mind when we get to online.
Okay.
So, all right, is there any other members of the public that wish to speak on this?
Mr. Chairman, could I confirm with the committee that the members all have the engrossed version of the bill? There was an issue with the copies.
Does everybody have the blue copy of the engrossed?
Excellent,
Okay,
thank you.
yeah, I think we got it. All right, and because we have another bill coming up as well, we'll limit time, but I always know you're concise, so.
You bet. Thank you, Mr. Chairman, committee. My name's Marguerite Herman here for the League of Women Voters, and I was in the Senate corporations when they made these amendments. So I want to speak in favor of the amendment about who can attend. And I think original language conceived of representatives for the public who I guess purportedly would go out and report to the general public and talked about, that probably, so there was little reason to expect that to happen effectively. So I stand in support of, as it is amended, we talked about how many people could be accommodated without being disruptive. I've talked to our clerk in Laramie County and she said, attendance, well, I guess it's both numbers and attitude. People were being, she had some experience with some disruptive behavior. So I think empowering or authorizing the clerk to determine, and yes, the public can be welcome, but we have 50,000 voters in Laramie County, and, you know, numbers very quickly could get out of control if the clerk didn't have control, didn't have the authority to limit that to a reasonable, but the room could handle. And the other thing that I kind of suggested, it was just a mild suggestion, is that actually the more that people see this process and understand this process, I think the more they'll trust the process and see that things are being done to ensure security, and to just suggest, and obviously it's not going to go into the bill, but just in general, is that if clerks had the capacity, technical capacity to stream this online so people could see the process, and as the machines are checked and are verified that they're accurate, I think it would go a long way to helping people. They don't have a representative per se in the room. They at least can watch the process and know that it's being done by the book, that some people are there, and, you know, if they want to, they can contact those in-person witnesses. But anyway, I just, the discussion and the subsequent amendment, the league supports. We think it keeps things accurate, and you've got the witnesses that can, you know, verify that things happened by the book, but it's manageable. And obviously, different counties, the clerk can determine what the capacity is for that.
All right. Any questions? All right, thank you very much. I appreciate it. Any other people in the room for this bill? All right, we'll go to online. We have one respondent.
Mr. Chairman, no one's raised their hand. My guess is that County Clerk Freese. So I will promote her to panelist.
Ms. Freeze, are you out there?
Good afternoon, Mr. Chairman. My video for some reason doesn't want to unlock, but
Okay, Clerk Freeze, can you identify yourself and then we'll get your comments?
yep, Julie Freese, Fremont County Clerk. I really don't have anything to add to what Mary did. I think she did a great job. I looked over the engrossed copies and our amendments, and would just like to reiterate what she said, is that we will try as best we can to do 5 days ahead of time for notification, but realistically, in our world, 2 days so that we don't get in trouble for not doing that would be more helpful. Besides that, if you have any questions that you'd like to specifically ask that we can answer, I'd be happy to stick around for that.
All right, thank you, Clerk Freeze. Any questions? Thank you very much for testifying.
Thank you.
All right, I will close public testimony on Senate File 28. Committee, what's your pleasure?
Move the bill.
Been moved by Weber, seconded by Brown. All right, are there any amendments? We'll have Minority Leader Ian first, and then we'll go to Representative Hoft.
Mr. Chairman, thank you. So I was looking, I mean, we worked this bill in committee last year, even though it didn't make it to the floor. And I was looking through some of the committee amendments, and we did talk about explicitly putting in the machines being resealed. So I'll put on page 8, line 3, right before the semicolon at the end of the line, insert, then the machines shall be immediately resealed.
All right, is there a second? Okay, it's been moved and seconded. All those in favor of the amendment, please signify by saying aye. Aye. All those opposed, no. All right, that amendment does carry. All right. So just for a matter of order, let's go down the list of the 5 amendments that could be put back in from the engrossed version on the Secretary of State's draft sheet that everybody has. If there is somebody that wants any of those amendments, let's take them in order. All right, so any other amendments? Yes, Representative Brown.
Thank you, Mr. Chairman. I would move that we put back in the First Amendment that we have here on page 2, line 2. I know we talked about this in the interim, and we did decide at that time that 5 days were where we wanted to go. I would like to go back with the 5 days, so I'm going to move that and see where we go with that.
All right, and for clarification on page 6, line 2, is
Yeah,
that
so we would
as well?
go ahead and make those to where they work together.
Okay.
So
Is there a second to that amendment? All right, seeing none, that amendment does not pass. Any other amendments?
Yeah,
Vice Chairman Locke.
Yeah, Mr. Chairman, I would actually move it to at least move the 2 to 4 days for in those 2 cases.
Okay, and is there a second?
Second.
All right, it's been moved and seconded that we move the 2 to 4 in both instances, correct?
Correct. Yes.
So page 2 and page 6. If that's understood by everybody, all those in favor signify by saying aye.
Aye.
Aye. All those opposed, no. Okay, that amendment does carry. Any other amendments? Yes, Representative Weber.
From the amendments that we had received from the Secretary of State, I would move page 2, lines 12 through 14, delete, same as the language is written, at the county's clerk discretion, not less than 3 members of the public, but not more than a number that will ensure orderly testing of machines.
All right, thank you. Is there a second?
Second.
It's been moved and seconded for the second amendment.
Mr.
All
Chairman,
those in favor, I'm sorry, discussion.
Mr. Chairman, would you want to move that with the other one? Again, these are about two times, so you might as well move both together.
Yes, the two that
Yeah,
matches is the
Yes.
second concur.
Thank you.
All right. All those in favor of the amendment, please signify by saying aye. Aye.
Aye.
All those opposed? Okay, that amendment does carry. Any others? Any other amendments? All right, we will move, I'm sorry,
Oh,
Minority Leader.
Mr. Chairman, I had an amendment if we hadn't moved those 2 amendments, but because we moved those 2, mine are not useful, so never mind.
Okay,
I'll call the question.
all right, question on the bill. Is there any discussion? Seeing none, please poll the committee.
Mr. Chairman, before that, could I just confirm the amendments to be adopted will be the page 2, line 2, the next one, page 2, lines 12 to 14, followed by page 6, line 2, and then page 6, lines 11 through 13.
Correct.
Correct. Thank you.
Yes, Representative Weber.
I think I forgot an amendment on page, my intent was to also move page 4, line 16. After the word challenge, delete within 5 days.
Right, and you wanted that as a separate amendment?
Yeah, I thought I added
All
that
right.
in, but I did not.
Since we've not taken a vote on the bill itself, I'll allow that. Is there a second on the amendment? It's been moved and seconded on page 4, after challenge, delete within 5 days. All those in favor of the amendment, please signify by saying aye.
Aye.
Chairman.
Oh, the
Just-
discussion.
Yes, please, Mr. Chairman, thank you. This is the only one that I'm really pushing back on. I think that if you leave it open-ended, it actually makes it dangerous where you could get into a situation where you could challenge the integrity of the machines right up to the day of, and that puts into question the entire integrity of the election. So I think having a limit, it may not have to be 5 days, but having a time limit, I think, is important there. Because the closer you get to the election, the harder it is going to be to deal with it.
All right. Any other discussion? Seeing none, all those in favor of that amendment, please signify by saying aye.
Aye.
All those opposed? That'd be a no also. That Okay, let's do it by hand. All those in favor of that amendment, please raise your hand. Okay. Got 3, 4. Ann, are you?
Yes.
Okay, 4. And all those opposed? We have 5. Okay, so that amendment does not carry. All right, back on the bill. Any discussion? Please poll the committee.
Mr. Chairman, this is a roll call vote for Senate File 28 as amended. Representative Brown,
Aye.
Representative Heft, Representative Johnson,
Aye.
Representative Locke,
Aye.
Representative Lucas.
Aye.
Representative Weber, Webb. And Weber.
Aye. Thank you.
Representative Yin.
Aye.
Chairman Knapp.
Aye.
Mr. Chairman, you have 9 aye.
All right. That does carry. We'll move on to the next bill, which is Senate File 82. Senator, welcome.
Thank you, Mr. Chairman.
Go ahead and introduce yourself and then we'll head right into the bill.
Absolutely. Mr. Chairman, Barry Crago, Senate District 22. It's my pleasure to bring you Senate File 82, Duties of Registered Agents Amendments today. And I'm gonna keep it brief, and we gavel back in, Mr. Chairman, at 1:30, so I probably will not be able to stay for all of the discussion on the bill. But I'll try to get through the bill quickly and then be available for some questions from you in the committee.
I apologize. We would have took you first had I known that.
So, Mr. Chairman, this bill stems from some issues we've been having back home in Sheridan County in particular regarding registered agents. And if you've seen the news at all over the last year or two, you've noticed that Sheridan County's been in the news about registered agents a lot. In fact, we've been in the news nationally. And in fact, we've actually become the place where you go. This is my belief. This is where you go if you want to file or start a company, and you want to use it for less than scrupulous purposes. And so what this bill is trying to do is fix that. We're trying to require the registered agents to gather a little bit more information about their customers. Essentially, it's a know your customer type bill. Who owns the company that you're representing is the registered agent. And that's pretty much the extent of the bill. If you look on page 2, and back up just a little bit, Mr. Chairman, right now, as a registered agent, you're required to know the names and addresses of the entity's directors, officers, LLC managers, managing partners, trustees, or persons serving in a similar capacity, and then the name, physical address, and business telephone number of a natural person who is authorized to receive communications from the registered agent. This just adds to that, and it adds that part there on Part D. Then it creates some exemptions, and the purpose of the exemptions really was to not gather up all of the companies that we believe are lawfully operating in Wyoming and aren't using the LLC laws or other corporate laws essentially as a shield. So any company that would have more than 100 owners would be exempt from reporting their owners to the registered agent. That makes sense. If you have more than 100 owners, you shouldn't have to do that. Or if you're a resident company, and that's the Part 2 there, maintains a fixed physical business location within the state that serves as the entity's principal place of business and is used by the entity for the entity's ordinary business operations. And then at the top of page 3, we also exempted out DAOs and DUNAs, which are obviously more sophisticated type business entities that operate in Wyoming, but because of their makeup, this would be really difficult for them to do. And so they would also be exempted out from the reporting requirements of this particular bill draft. And so again, point of this, Mr. Chairman, is to try to create some sort of mechanism where those folks that are filing within Wyoming have to report enough information to their registered agent that they can, that it serves as a deterrent for some of these entities, a lot of which are coming from not only out of state, but a lot of them are out of country, like the large majority of those that we're having issues with, we believe, are coming from out of country. And so this would help alleviate some of that stress on our businesses back home and for example, and I don't have my exact statistics in front of me right at the moment, Mr. Chairman, but the chamber in Sheridan gets about 5 calls a week on this particular issue. People are trying to hunt down entities that are registered in Sheridan or in Sheridan County, and they're not entities that obviously exist there, but because the chamber is there, people call and want to know, hey, what's going on? They're typically fraud related. I believe in the last couple years, there's been several hundred police investigations in that county alone regarding this particular issue. I know other counties are experiencing the same thing. I know Fremont County's been having all sorts of issues as of late with this particular issue. The one thing, we had a lot of discussion about this bill on the Senate side, and I'll be the first one to acknowledge this is not going to solve all of the problems. It's just a step in the right direction. I'm hopeful that we take this up as an interim topic because I think we need to do a deep dive into what's really going on here and what's the best way to figure this information out. I think you're going to hear from some folks behind me who will tell you that there's probably a better way than what I'm proposing. They're much smarter than me. And they probably do know a way that would help us get to exactly where we want to go. It's just not something we can do probably without some interim work. And so I'm all in support of what these folks are trying to get us to do and the direction they're trying to go. I probably won't be able to sit here and listen to what everybody has to say, but you should, because there's some really smart people in this room that have some good things to say about this. And hopefully, as we work it in the interim, if we're able to get it there, either on this committee or on blockchain or both, that we can get to the bottom of this because it's causing a lot of issues around the state and in particular my district. So I'm happy to answer any questions.
Thank you. Any questions for the senator? Yes, Representative Lucas.
Thank you, Mr. Chairman. Senator, thank you very much. I think this is definitely a topic worth discussing. So when we get this list of addresses and names and all of that, is any of this verified or does the LLC just provide a list?
Senator Craigle.
Mr. Chairman, Representative Lucas. So I think it probably depends on who your RA, who your registered agent is, but you are supposed to keep valid information on hand. There's actually enforcement mechanism within the statute. The Secretary of State has that. It's in section, I believe it's 109. But unless there's a complaint or an investigation into that, you never get that far. And so this would hopefully give the Secretary of State's office a little more teeth to be able to do some of that. Again, it's not going to solve all the problems. People who want to commit fraud are still going to commit fraud. I think that's what you're going to hear from some of the folks behind me is maybe there's a better way to verify some of this information without just accepting what the people filing the LLC have to say.
Yes, Vice Chairman.
Thank you, Mr. Chairman, and thank you, Senator. So this appears to be a very significant policy shift. And my question is, your thoughts, probably you know better than I, of overall impact. For example, I mean, significant changes to how we're doing things, which again, I think the fraud issue is real and there's no question. It's in the news all the time, but just wanted to get your thoughts because I know you have to run and I apologize for taking your time, but thank you.
Senator.
Mr. Chairman, Representative Block, no, thank you for the question. I think that's the discussion ahead of us, right? There will likely be less filings. No one's saying there will not be. It will change the privacy rating of our corporate laws, especially our LLC laws. And I think that's a discussion we need to have. I actually brought this bill 2 years ago when I was still your colleague, and we just didn't take it far enough. It didn't go anywhere, and I'm bringing it back because this is, whether the bill passes or not, this is something we need to do as the legislature. We need to dig into this, and we need to listen to the experts on what's the best way to do this. There are other states doing this. I think we can learn from what some of them are doing. Again, I'm not smart enough to know how all of the technology that's available to us would work, but there are people in this room who are, that could walk us through that. And I'm happy to work on that as we go forward. I mean, hopefully we can, move the bill forward and and work on it in the interim to get to a bigger, broader, better based answer.
All right. Any follow-up? All right, Senator, we'll get you on your way. Thank you.
All
We
right.
appreciate you being here.
Thank you, Mr. Chairman. Thank you, committee.
All right, next we'll have the Secretary of State's office.
Thank you. Thank you, Mr. Chairman. My name is Chuck Gray. I'm the Wyoming Secretary of State. I'm joined to our left by our Policy Director and General Counsel, Joe Rubino. To my right, Colin Crossman, the Deputy Secretary of State. And as you remember him from our work during the 2024 interim on the Business Fraud Working Group, the former director of our business division, Mr. Naaman, our former deputy, went to the U.S. Attorney's Office, which we're very excited for him in his new role. And we're excited with Mr. Crossman ascending to the deputy spot. I want to start out by saying that I support this legislation as a tool that can be used to provide a heightened sort of know your customer standard for commercial registered agents so that they know who they're representing. I think it's appropriate for us to take a few minutes, Mr. Chairman, to discuss our office's work both administratively and with you, the Wyoming Legislature, to change the tone and combat business fraud and abuse of corporate filings in Wyoming. And as you know, Mr. Chairman, we had our Business Fraud Working Group. One of the things I really wanted to do in our administration was to change the tone, where predecessors would often say nothing to see here, nothing to see here. I thought it was really important that we make clear that Wyoming is taking fraud seriously. And I think that's going to provide a good segue into the bill to talk a little bit about that. Attacking fraud has been a huge priority of our administration. To date, we have really utilized the existing statute allowing dissolutions for any fraud that is received in our office. It has to be fraud with a filing in our office. And when I entered, we really have no record of this being used by predecessors, but we stood up this process pursuant to existing statute. And since then, we've processed about 200 affidavits. It's a manual process to dissolve business entities in accordance with Wyoming law. So the way this works, and we just launched a new page on our website, really laying this out, a one-stop shop for attacking fraud, is somebody who is a victim of address fraud or other instances of fraud with filings with our office, fills out an affidavit, they submit that affidavit, and we dissolve the business pursuant to Wyoming law. Just last year, in partnership with the FBI, we dissolved 3 entities tied to North Korea's nuclear weapons program, Vini Vidi Vici, because we take that very seriously, foreign adversaries utilizing our code and trying to hide behind Wyoming code. We've also increased the number of audits of commercial registered agents to ensure compliance with the Wyoming Registered Agents Act, and plan to continue to audit these commercial registered agents to ensure that they are in compliance with the law. We also took legislative action. We convened in the 2024 interim the Business Fraud Working Group with the Joint Corporations Committee. Mr. Chairman, as you remember, and also with county officers, including Assessor Berg from Fremont County, we worked on a suite of bills to take on business fraud. A number of those bills did make it through the process. However, we did have one, particularly with regard to verification of third-party filers, that unfortunately did not make it through the process. I do think that legislation was well vetted, well timed, and placed some of these large filing mills on notice that we were taking this issue seriously. And that was one that I was hoping we could bring through that did not go through in the 25 session. Now, in terms of this bill, which Senator Crago has filed now twice, I'm a little unclear because in a moment he seemed to withdraw the bill and then he said, you know, keep moving it forward so the conversation can move forward, which has been the line the Senate has used on the floor in the last few days. But I think that's fine to move the conversation forward, but we also really need action. And in terms of what this bill does, this fits into the requirements of commercial registered agents in requiring commercial registered agents to have certain information on file, specifically the names and address information of an entity's owners, including partners, members, and shareholders, with certain exceptions as specified. To date, Wyoming law requires certain contact information, which is a somewhat low threshold, but this would be a large policy shift to require registered agents to keep beneficial ownership information for all entities they represent. This information can then be audited by our office and provided to law enforcement for use in criminal investigations. Now, requiring beneficial ownership information to be kept on file with a CRA would open up the door for our office and any law enforcement agency involved in a criminal investigation to obtain that information. Now, Mr. Chairman, you know what has happened with our filings. They continue to go up. Fiscal year 2025, 830,000 filings. That's up from 675,000 filings in fiscal year 2024. We're one of the few revenue centers for the state. Revenue went up to $59.6 million in fiscal year 2025. That is a $9.1 million increase from fiscal year 2024. Those 20% year-to-year increases have been occurring throughout my term. And we have continued to meet our 15-day statutory deadline without any increases in staffing. And I'm very proud of that, as we have become one of the few revenue centers in the state. We answer the phones. We have a 15-day statutory date certain where we have to respond. And so we're really proud of that. This is a change, as Representative Locke said. I think that it should continue to be moved forward, so we continue this conversation. I really believe that. I'm supportive of that. And I was surprised, the senator appeared to flirt with withdrawing it. I'm not clear of the status after that, but I am supportive of continuing to move it forward and continuing the conversation. And we must attack business fraud. We really must do that. And I can tell you this is a huge, huge priority of our office and will continue to be.
Thank you, Mr. Secretary. Questions? Vice Chairman Locke.
Thank you, Mr. Chairman, and thank you, Mr. Secretary. And just in terms of methods of attacking fraud, are we going to hear from people who can give us more insight from either your office or other folks? Because I think that's the area that I'm a little lost here. Now, timing wise, I would be honest with you, to implement this in any kind of short timing is the potential impacts are significant. So I raised that as an issue on this table. I asked that question as well as to the people on this committee, the timing, because to implement this, attempt to implement this, even I know in some cases, bills like this get implemented and they implement them and they give years to actually implement, because when you start talking about notices and everything else we're doing, when you consider the scale of the change to policy, it's significant. So these are the things that worry me most. I agree the conversation has to occur. Does a conversation occur, in committee in a budget session or in an interim session? Is certainly an open conversation right there. But I would like to understand your thoughts on this method and technique and potentially its effectiveness. I mean, it's one of those things where, I think we've heard some people say, oh, we're just going to move it forward for the conversation. That's a great thing to say. But I look at this and I think, man, I'm not sure I know how this is actually going to impact fraud, other than the fact it's going to stop people from filing in the state. Maybe that's good, but I'm not sure I see how this, for lack of a better term, threads the needle and keeps us open for business. It's not clear to me. So
Thank you.
your thoughts are appreciated.
Mr. Secretary.
Mr. Chairman, Representative Locke, really appreciate it. And I do want to be clear. I understand your points and I appreciate them. I believe it should be moved forward to continue the conversation. We've been trying to do this for 3 years, and look, House has been great. I mean, we requested this three times in the interim. We got it in 24, but we just want to keep this conversation going. Now, in terms of implementation, I think you bring up great points. And I was totally against the CTA, which is different. The CTA is basically providing beneficial ownership to the federal government, and it was a Democrat. They broke a Trump veto on that, and that was passed in 2020, and they did not implement it until it was January 1st, 2025. So they gave like 4 years for implementation of that one. Now this bill July 1st, so like 4 months. And so I do think that there's some implementation questions. Now, there is a huge difference, and this was one thing on the Senate floor that they did a good job of explaining. There's a huge difference between reporting beneficial ownership to the federal government, which I am totally opposed to, and reporting beneficial ownership to a CRA, which is what this bill does. And I think that is an important distinction. I think some will try to explain how that's really a distinction without a difference in their opinion. I would push back a little on that, although I understand that argument. But I think in terms of implementation, there are questions, 4 months versus 4 years. I mean, I think that is one thing in the bill that needs to be addressed.
All right. Yes, Representative Brown.
Thank you, Mr. Chairman. Mr. Secretary, I share Representative Locke's concerns about people registering in the state. I was wondering if we could have Mr. Crossman's opinion on this, and being that he's the head of the business part of the Secretary of State's office, and hear what he has to say on this, and
Sure.
if he has any concerns on that.
Mr. Crossman.
Thank you, Mr. Chairman. Representative Brown, the opinion of the office is that we support this legislation. Thank you.
And look, Mr. Chairman, I think we've testified that we think it could lead to a reduction of some filings. But I mean, that's the question. And, you know, Senator Crago put this on the train tracks. That's where we're at right now. You know, you had multiple senators say on the floor that they don't think it does anything, but then they voted for it. And they said that on the floor. So, you know, I think that there has been some questions on that in my mind. But I think it is important for us to show that we are going to address fraud. I really do. So I think, you know, we talked about 35 to 40% in the other hearing. That's just an estimate. We don't know.
All right. So as a limit of time, I agree and agreed that it's confusing. The senator seemed to imply this would go to interim.
Yeah.
For more consideration. So because we have a lot of people online, and I feel like there might be some public testimony that's helpful for the matter of time. Thank you for your testimony, and we'll go to any other members of the public that are wishing to speak on this. And we're going to limit the time to about 1.5 minutes per person. I apologize for that, but we'll go ahead and start over on my left. If you would. Oh, okay. All right. We can do that. Go ahead and introduce yourself and give your testimony.
Am I on?
If you just press your button and the green light's on, you're
Light is on.
moving.
Great, excellent.
And just make sure your mic's a little closer to you.
All right. Thank you, Mr. Chairman, members of the committee. My name is Dallas Lane, and I, 2 years ago, at the beginning of 2024, purchased a small registered agent business called High Plains Agency, which I operate here in Cheyenne. We have about 800 to 900 entities that we serve as the registered agent for. And I'm here today to speak in opposition to this bill and in favor of an interim committee that would look at this. A couple of things. I want to just maybe pull back a little bit. Registered agents have a singular purpose under the Wyoming statute. Our purpose is to receive service of process, whether that is a complaint in a lawsuit, a document from the Secretary of State, a subpoena issued by law enforcement, and then take that legal document and provide it to our customer so that they can deal with it. That is the singular purpose of a registered agent under Wyoming law. Many registered agents do additional things such as filings, maybe some do office rental, different things like that. But I think it's important to realize that we don't have any control or information over those entities or the operation of those entities. I talk to people on the phone all the time who say, can I add my wife? Can I add my son to my LLC? I say, call your lawyer. That is not my job. What I put in my records, what is at the Secretary of State, is not the legal determination of who the owners of that entity are. So I think it's important to think about that. The next thing I would just say is that this bill makes me extremely uncomfortable. And I'm uncomfortable saying that I'm uncomfortable because I do not in any way want to give the impression that I condone fraud or looking the other way, or in any way that things are just fine and we don't need to do anything. I agree with the Secretary of State and his staff and with Senator Crago that there are problems in this industry and problems for people like myself. I have spent 2 years trying to figure out the ins and outs. How do I deal with the Secretary of State? How do I get things filed? How does their online system work? How many days does it take for things to happen? It's incredibly complex. And I think some of the problems are that we do have a very antiquated system. I have filed documents at the Secretary of State in other states. In Colorado, if I'm the person who files that document, I get an email from their system anytime that entity is modified, anytime any update is filed. In North Dakota, I have a password. I have to be authorized by the client, or if I'm the filer, I have to authorize my customers and clients to be people who can change those records.
Thank you. I'm sorry to cut you off,
I'm
but we
so-
got to
yeah,
get
I
to a
am
lot
so
of other
sorry.
people. If we do go to interim, we would love to have your
Thank you,
testimony
Ruby,
during
and I'm
that
happy
time
to answer
too.
questions here or at any point. Thank you
Okay,
so much.
thank you. Next.
Thank you, Mr. Chairman. My name is David Pope. I'm a CPA and a chartered global management accountant licensed in Wyoming. I have been an accountant for 39 years. I have provided CPA services through my firm for 30 years. I am a past member of the Association of Certified Fraud Examiners, and my firm was directly involved in detecting and helping secure what was at the time the largest civil fraud award in Wyoming history. That case was a Fremont County case. For the past several years, I've also served as one of the governor's liaisons to the Select Committee on Blockchain and as an appointed commissioner to the Wyoming Stable Token Commission, where my primary role is to advise the commission on control systems and appropriate accounting treatment for an entirely new asset class within the financial system. I am speaking here, though, strictly on my own behalf. I also operate a small registered agency in Wyoming as a convenience for my clients. Senate File 82 in its current form would have little to no practical effect on my firm or the way we serve clients because it is such a small part of my business. With 30 years of experience in accounting, fraud detection, and now emerging financial technologies, I can state clearly SF-82 will have little to no meaningful effect on actual fraud in the state in its current form. Fraudsters who intend to deceive will simply lie to their registered agent in the same way they lie to any other party or authority. The bill does not add verification, public disclosure, or proactive enforcement mechanisms that would meaningfully disrupt fraudulent schemes. What the bill will do is push owners who have legitimate, non-criminal need for privacy to move or form their entities in other states, Delaware, Nevada, elsewhere. Those states continue to offer anonymity. I'm going to cut my opening statements a little short at your request, and because I appreciate your need for time. But I would like to end with a story and then be open to questions, because I've given you a list of amendments that I think are the only way that this bill should move forward. There's 7 of them. Those amendments, this is a huge shift in policy away from privacy. Those amendments help mitigate the problems that this bill currently causes. And the real issue with those amendments and this shift in policy is it really does need to be addressed in an interim where we can vet out all of these things and their possible effects. You don't, as much as I don't care when it comes to the reputation of the state, because I want the state to have a sterling reputation. I absolutely want to maintain that. I don't care about the money that this will cause to go away, except we need to consider first, then in past testimony, the Secretary of State has said that this could mean a 20% reduction in filings, which could mean up to $15 to $20 million to the state. we can't take that action without vetting everything first and making sure that it does what it says it's going to do before before it costs us that money. So I'll end with a story. And
I thought that was the story.
No, that wasn't the story. I'm sorry. You know, I wrote an op-ed about this for the newspaper or the Cowboy State Daily, and even they tell me I write too much and talk too long and all of that. But the story is about a doctor that I met at the Republican National Convention in 2016. The doctor is a Republican, and he is from a deeply blue state. He is vocal about his opposition to various procedures and things like that that are not that he believes are not appropriate. What he did was he formed a Wyoming limited liability company that him and his wife and his 2 children own. This bill would effectively dox them. This bill does not guarantee the privacy of the information that's given. There's nothing in statute that requires registered agents to keep the information they hold confidential. That's one of the amendments that I have, is to create a subsection within the statutes that requires RAs to do that. If we're going to increase the amount of information that a registered agent is required to have and hold, we need to increase the amount of security that surrounds that. And if you don't believe that doxing is a problem, ask President Trump about his tax returns that were released by a government contractor, a proxy to the government, which is what we're talking about here. The RA will be used as a proxy for the Wyoming government to maintain information. That was a contractor. Last thing, and I promise, ask Mitt Romney, whose foreign bank account information was doxed by employees of, I believe it was employees of FinCEN, the government agency responsible for keeping that information secret. I will take any questions about my suggested amendments. I think they are the minimum I would see in helping this to actually have teeth and to provide the security of the information that you're asking for.
Mr. Pope, thank you. And if you could leave those amendments with staff so that we can get copies with them or get them online. Just for the sake of the people waiting online, my plan is to extend this public comment to our next meeting on Monday, just so that you know you're not being left out, but we'll go ahead and continue on with people in the room.
Mr. Chairman, my name is Kristen Lee, and I represent the Wyoming Trust Association, and our witness is online, so we'll do our public comment when you reschedule it next time.
All right, thank you so much. I appreciate it.
Good afternoon, Mr. Chairman, members of the committee. My name is Matt Kaufman. I'm a partner with the firm of Hathaway and Coons here in Cheyenne. I've been a corporate attorney for about 20 years, and also a governor appointee to the select committee, the blockchain select committee as well. So I've worked on some of these issues ancillarily. To speak directly to Senator Crago's comments, I've actually worked with him on this very issue. And I want to talk to you all about a couple of possible routes we could take other than this that I think would be more effective. I want to echo the comments of everyone who's testified already. I agree there is an issue that we can address, but we need to be very careful about how we address that. Wyoming has worked long and hard to become one of, if not the preeminent state for business incorporations and LLC filings. And I'm here to tell you, it's being noticed throughout the country, and there's great momentum behind that. There's great opportunity, and there's great celebration, candidly, for the state behind what we've created. There's no doubt that there's some fraud, but what this act will do, in my opinion, is create chaos. The reason it will create chaos is, as Ms. Lane testified, statutorily registered agents don't have corporate authority. They just don't. And that doesn't exist anywhere, right? And so if we are to create corporate authority for registered agents, we're putting ourselves at a tremendous disadvantage. Conversely, one idea that I have discussed with Senator Crago and a few others is legally, if you look at the statute, when you file an LLC, someone has to sign on the dotted line as the organizer of that LLC. The organizer has legal significance from a statutory perspective. It would not be that difficult, right, to require an organizer, if you are signing on someone else's behalf, to certify that you have certain information available to you, right? That's a path forward that could solve a lot of these issues, right? I'm looking at this from a perspective of an attorney right now. I have confidentiality requirements and ethics requirements as an attorney. If the Secretary of State's office calls me and says, hey, we need to know who the owners of this LLC are, am I going to violate my law license potentially, right? Or am I just going to give up that information willingly? Or do I give up the information and get sued by my client? Or do I just resign as registered agent and say, sorry, I don't have it because they're not complying? So I think that the potential frictions this creates are big, and I don't think those have been thought all the way through. Additionally, we haven't even talked about what's likely to happen in the market, which is mass resignation of registered agents, right? We have hundreds and hundreds of thousands of LLCs. If registered agents aren't able to get that information within 60 days of this act going live, which is, in my opinion, ridiculous, that's never going to happen. Registered agents are going to be forced to resign, right? Now the Secretary of State's office is faced with, thousands and thousands of delinquent entities, many of which are likely going to be completely legitimate, right? The last point I just wanted to make is I have personally fielded phone calls from people, particularly with oil and gas companies. A lot of times it comes with LLCs when they're trying to track down mineral interests. And they'll see that our firm is listed as a registered agent, and they're calling asking for us to identify who the owners of that entity, that mineral interest are. Again, ethically, legally, I can't give them that information. We know for a fact that many times the people are seeking that information are themselves bad actors, right? This bill puts me in a position of having to give that information up for someone that I might have a client or a contractual obligation with. So again, I could go on and on and on, but I think the potential problems that this bill poses, as Mr. Pope and others have said, does not solve the issue that we all agree can be addressed through other means. So I would urge you all to push this to an interim topic as well. I'm happy to participate. I think a lot of ground could be made by studying this and coming up with a proposal that works.
Thank you. And this is a pretty big policy change, so I am going to leave testimony open, public comment open until our next meeting Monday, and we'll notice that as well. With that, is there any other business to come before the committee? Yes. Vice Chairman Lott.
Thank you. And I guess I'm going to ask the question of the folks here. Are you folks going to be able to potentially continue some of these conversations? Because obviously there's so much detail here that even if we're going to resume this on Monday, I would like to hear a little bit more and see where we go from there, because it's important. I just wanted to throw that out. Maybe that's something I shouldn't have, but I wanted to at least throw that out.
Yeah, I think with all the testimony that's coming forth, well, obviously, we're not going to rush through this. And it may very well turn into an interim topic. So I think you're correct in that.
Mr. Chairman?
Yes, Mr. Pope.
Thank you for recognizing me. Representative Block, this is tax season for me, but I have cleared my schedule until this bill is determined, so that I can be here and present for questions and to offer feedback. So thank you.
Thank you very
Thank
much.
you, Mr. Chairman.
This meeting is adjourned.